An Americanized pronunciation, I guess. Yeah.
I think they can appear online. All right, welcome everyone. Good afternoon. My name is Lauren Williams, Adult and Community Services Manager here at the Columbia Public Library. Thanks for joining us for today's Lunch and Learn, those of you in the room and those of you on Zoom. We are learning today about the Supreme Court's current term, cases and their implications. And today's Lunch and Learn, as always, is co-sponsored by the library and the League of Women Voters of Columbia-Boone County. As I said, we have people attending both in person and on Zoom, so just a couple of housekeeping items. If you're on Zoom and you want to ask a question during the Q&A period after the presentation, please use the chat feature. And we ask that you use, there's a little drop down arrow. If you would select everyone so that everyone can see what question you're asking, that would be great. And for those in the room, we'll walk around with this microphone to make sure that everyone can hear the question that's being asked. And we are recording this presentation, so it will be available in the next day or two on both the League's YouTube channel and the library's YouTube channel for future viewing. And now I'd like to welcome Marilyn McLeod of the League of Women Voters of Columbia-Boone County to say a few words and introduce our speaker.
Thank you very much, Lauren. My name is Marilyn McLeod. I'm a member of the board of the League of Women Voters of Columbia-Boone County, and I'm just delighted to be here. I'm taking the place of our regular hostess from the League, and we miss her, so I hope I can do us justice. Thank you, Lauren, and the library for being a co-host of this event, and thank everyone for attending, coming out today on this beautiful day, and also for those who are online. Today, we are delighted to have a guest speaker, Professor Rigel Oliveri, who is on the faculty of the University of Missouri Law School. Give you a little background about her. She obtained her BA from the University of Virginia, where she was inducted into Phi Beta Kappa and graduated with highest distinction. She obtained her JD from Stanford Law School, where she was an articles editor for the Stanford Law Review and was elected to the Order of the Coit. She clerked for the Honorable Stephanie K. Seymour of the United States Court of Appeals for the 10th Circuit in Tulsa, Oklahoma. Prior to coming to Columbia, she served as a trial attorney with the U.S. Department of Justice in the Civil Rights Division, Housing and Civil Enforcement Section. In 2003, she was awarded a special commendation from the Attorney General for outstanding service. Following those great works, she joined the law faculty in 2005 and served as the law school's Associate Dean for Research and Faculty Development from 2009 to 2015. She currently serves as a commissioner for the Columbia Housing Authority and on the board of Mid-Missouri Legal Services. So we are delighted to have you present today. Thank you.
All right, I have unmuted myself. Hopefully everyone can hear me. Well, thank you. Thank you all for being here. Thank you to the League of Women Voters and to the library for hosting this presentation. I am professor at the law school, and one of the classes that I've been teaching since 2017 is constitutional law. So I thought today for our program, we could just go through some of, only a few, of the court's most important cases for the current term and talk about kind of what they mean, where they might go, and the implications of them. And so before we start, I just want to, I always tell my students, you know, the Supreme Court is made of people, as are all of our government institutions. But the Supreme Court in particular, because there's 9 of them, and because they have a record of, you know, where they fall on certain things, we do a lot of prognosticating. We try to read their minds and figure out how they're going to rule on certain issues. And they actually, there's a group of academics who actually kind of score them ideologically, using a system that, you know, I'm not sure how scientific it is, but they basically score them every year, because people can of course move around on the ideological spectrum. There's certainly histories of justices that have moved to the left and the right the longer they serve. So this is a relatively recent score of where the justices are right now. And as we can see, there is a conservative supermajority. There's enough conservative members now. And when I say conservative, appointed by Republican presidents, but more significantly falling on the conservative side of the ideological scale, such that, you know, we can expect many cases to fall comfortably. We can predict that, you know, cases will break in a conservative direction. Not always, sometimes they surprise us, but this is pretty much the landscape that we have. And in particular, I find it really interesting. Justice Kavanaugh and Justice Roberts are 2 kind of moderate centrist justices, in relative to the court as a whole. And certainly, you know, I think, you know, during their confirmation hearing, certainly during Kavanaugh's, no one would have expected that to be the case. And I think some of that is just a sign of how far to the right the court has moved, that those 2 are kind of the middle centrists.
Yeah.
But that's where we are. I did have a slide that I actually took off, but now I kind of wish I'd left on, that showed also people's views of the Supreme Court in recent years, and how sort of the Supreme Court went from having a pretty significantly high favorability rating, certainly compared to the rest of government, to kind of falling down with favorability ratings kind of in the low teens now, comparable to how people feel about Congress. And most people aren't a huge fan of Congress. So in a sense, it's sort of too bad that it looks like whatever sheen or luster they had, kind of based on their intellectual pursuits in writing opinions and sort of coming up with legal frameworks to justify what they were doing, that shine seems to have come off a bit. And there's a variety of reasons that, you know, I don't nearly have time to get into, but it definitely seems that people are viewing the court more as a political engine like the other 2 political branches, and a little less like the kind of wise people in black robes that they, you know, like to present themselves as. So we'll see. Public opinion is fickle. But let's jump into some of the cases. So I selected a few and I've got them grouped. I think the most important case I've decided to talk about first, but it's hard.
What's burning?
So it's hard to say. But this is one that I think has the greatest significance for everybody's lives and for the structure of our government, and how our government functions. And it is about herring fishermen. So, of course. So the really narrow issue here has to do with the National Marine Fisheries Service as a federal agency. They want to have federal monitors ride on fishing vessels to monitor the catch and how the practices and things like that, to make sure that they're doing things in a sustainable way and an environmental way. And they would like to make the fishermen pay for the cost of the monitor. And the fishermen feel that this would be prohibitively expensive and would really cut into their profits and maybe make some of them go out of business. So that's a real concern for the fishermen. Why do we care about this here in the middle of Missouri? We care about this because the real issue here, and the question that the court granted cert on and has taken oral argument on, is whether or not a federal agency can come up with a requirement like this that you have to pay for the monitor, when there isn't anything specific in the federal statutes, the Marine Fisheries Act or any of the kind of other legislation that speaks to this question one way or the other.
That'd work. That'd be enough.
Statutes have been to give authority to
We need to
make
get another package out.
Mhm.
and enforcement to these kinds of
Okay,
agencies.
if we have another package, that's one reason for going to.
Sorry,
That's really strange. I don't know what.
what's happening?
Oops.
I'll keep going, I guess.
That again, so I can sit what you just said again.
Sure. So the question comes down to whether an agency like the National Marine Fisheries Service can develop the kind of rules and regulations and requirements like this on paying for an onboard compliance monitor when they haven't, the statute, the National Marine Fisheries Services Act, is a law passed by Congress that gives the agency the ability to enforce the act and propose rules. But the statute doesn't say anything about this particular topic. And so the question is, how much freedom does the agency get to have to come up with rules like this when they haven't been given clear, specific authority by Congress? They've been given some general authority to implement the statute as it is written. And so the question is, when the statute doesn't specifically speak to something, is the agency allowed to fill in, and just do what it thinks is right? And then kind of the next level question, are courts the best arbiters to decide whether or not the agency has stepped out of its bounds? So should courts review these kinds of agency decisions? And back in 1984, the Supreme Court had answered this question in a case called Chevron versus Natural Resources Defense Council, where it had said, leave it to the agencies. If the law isn't clear, if it's ambiguous or it just doesn't speak to something, we'll leave the issue to the agencies. Those are made up of professional people who kind of do nothing but work on kind of these highly specific issues. And for a long time, that was very much a settled precedent. Chevron is one of the most cited cases in all of constitutional administrative law, because this happens all the time. If we think about it, really the people who make most of the decisions in our government are people who work for agencies that enforce the statutes that Congress passes. And so most of our law really comes from these agencies, and it's all kinds of minutia, water safety, workplace regulations, environmental stuff, you name it, food and drug, planes, all the things that kind of get regulated, it's done by these agencies. However, in recent years, the Chevron doctrine has come under a lot of criticism. Some justices who are on the court had criticized it and said it gives too much power to these agencies. They're unelected. And Congress should be the one speaking if they want specific things done. And sort of again, on the next level, the court should be able to step in and tell the agencies when they've gone too far or done too much. So the court had already been kind of whittling away at the Chevron doctrine in different ways, and cases, specifically cases brought against EPA regulations, and even some COVID era regulations from a few years ago were being challenged as being kind of agency overreach. So we knew this was coming. We knew this case that was going to squarely challenge Chevron, instead of chipping away at it, should it be overturned completely? And so that is the case that is before the Supreme Court right now. And it is not clear how the Supreme Court will come out. There are definitely some justices who want to get rid of Chevron. The liberal justices appear more likely to want to keep it. The centrist judges appear to be kind of skeptical of this doctrine. On the other hand, they're also terrified about what happens if it goes away, Because then that means every agency regulation can be brought and challenged in a federal court. And the federal courts would have to, exponentially increase in size. And there's no way, if there's one thing that federal courts are afraid of, it's a floodgate of cases coming, tsunamis of cases coming at them. So they're very worried about what this will do just to the balance of power and the balance of work. For better or for worse, the agencies do a lot of this work and they just sort of quietly do it. And to suddenly open up what they're doing to judicial scrutiny could be kind of would change things dramatically. And of course, then the other solution would be, well, then let's just ask Congress to legislate in a much more specific and careful way about everything that it does. And I don't think anyone thinks that's going to happen anytime soon. So that has been argued, and we're not clear about where it will come out. Was definitely some trepidation expressed by the justices about what the meaning of this would be. Yes.
So our Supreme Court justices supposed to consider practical ramifications of, like you expressed about flooding the courts and Congress not being very good at doing much of anything. Is that also a matter of judicial philosophy, whether they have to think about that or not?
Yes, yeah, so that's a really good question, and for folks at home, in case the question was sort of, is this practical question about the floodgates of litigation, the kind of thing that the courts like the Supreme Court will look at? And the answer is yes, they will. They'll kind of look at all sorts of tools in their toolbox when they're considering ramifications of their decisions. Sometimes they don't
They
look
don't
at that.
necessarily feel compelled to, though.
Right. Right, it's a
Okay.
thing that certainly, gets argued and was argued, and they could look at. So, and it definitely seemed to concern a couple members of the court. Justice Barrett in particular said, what's gonna happen to us if we rule in favor of the herring fishermen. So they will consider things like that. But we will see there's other cases where they don't do that. Which makes this area really challenging because they can kind of pick and choose what levers to pull. And that's one that I think they may have to pull that lever for this, because I just don't know that they can squarely overturn this precedent without chaos ensuing. So that's a really big one. Probably another one that I think is significant. It's on the issue of firearms, gun control. And I think this one is really important for a couple of reasons. The issue is whether there's a federal statute that prohibits people who are subject to a restraining order, like a domestic violence restraining order, from possessing a firearm while they're subject to the order. So at issue in this case, this guy, the defendant, Zaki Rahimi, was somebody who everybody can all agree should not have had a firearm. He had been involved in multiple shootings. He had abused his then girlfriend. He physically assaulted her in a parking lot and then shot his gun in the direction of someone who witnessed the assault to try to scare them to say, don't talk to the police. He'd been involved in multiple other shootings and crimes. Pardon me. His girlfriend got a restraining order against him, which meant he should not have been able to possess his gun. The police came to his house to investigate a different shooting that he was involved in, a different crime, and discovered that he was subject to the restraining order. They found the restraining order, a copy of it, at his house, and they found his guns there. So they charged him separately beyond the other shootings with violating this particular federal law that said he shouldn't have been having a gun in the first place. Once the protective order applied. The Fifth Circuit Court of Appeals found that this restriction on his ability to possess a gun after he had been subject to a restraining order violated his rights under the Second Amendment unanimously. And so the question has come to the court, why on earth would this Fifth Circuit Court of Appeals rule in such a way The reason they did was because in 2022, and we will often have to look back at previous cases to understand what's going on. The Supreme Court issued a ruling, this was authored by Justice Thomas, who's a very kind of strong textualist and kind of historicist. Where basically he was striking down, and the majority of the court that agreed with him, were striking down some of New York State's handgun licensing procedures and systems. But the key part about this opinion, this Bruen opinion, was that Justice Thomas said, in order to pass muster and not violate the Second Amendment, any gun control laws or firearms restrictions have to be the kinds of things that were in place in 1868. We have to be able to find a historical analog, because that 1868 is when the 14th Amendment was passed. And the 14th Amendment that guaranteed equal protection and applied many of the Bill of Rights to the states. So it was a sort of at that time that we would look to see what was acceptable at that time. And if this was a practice that was common then it can be acceptable now. And what New York had been doing hadn't been the kinds of things that had historical analogs that went back that far. And so that case, New York's licensing system was struck down. So the question today is, was there something similar to the domestic violence restraining order and the removal of someone's weapons as a result of that in 1868? Right. And of course, the answer is no. They didn't have domestic violence restraining orders. They didn't have a concept, I think, that was in the law that domestic violence was a thing that was not good. Women couldn't vote. I mean, there's just all sorts of things that historically are extremely different from then. Now there is some history of rules that, a dangerous person might get their guns taken away. The sheriff might show up and take the guns away from somebody that everyone thought was dangerous or was having some sort of problem. So this really just illustrates the reason I wanted to talk about this, both because it's got a fairly profound effect on women, who are most likely to be the ones obtaining such orders and were most likely to be killed by a domestic partner with a gun. But also just because of the decision making here, and the method of analysis is just, I think it's been pretty mind blowing for a lot of people to have to look back to 1868. It's confounding for the court because they have to basically suddenly become historians and comb through historical records from that time, and then draw analogies with things that may or may not be good analogies. So it's a very hard kind of path that Justice Thomas has opened up by saying this is how we have to interpret the Second Amendment. We have to do it historically because it leads to all sorts of uncertainty and results that may be problematic. I think when this case was argued, it was pretty clear that a lot of people in the court were feeling uncomfortable with what the ramifications of this would be if they allowed the Fifth Circuit's judgment to stand. They felt this just can't be right. But the question will be, can they dig around in the history enough to find something analogous enough to uphold this federal law? Yeah.
Do you have an opinion about how the felon in possession laws have stayed unchallenged, given this historical analog?
Yeah, and so I think the felon in possession, what's tripping up the domestic violence restraining order issue is that there hasn't been like a formal adjudication with a trial that the person has committed a crime. The felon in possession laws, once someone's been adjudicated and they've been found guilty, and so I think there is historical precedent for that, but there was no domestic violence restraining orders then, and so there's no precedent for that they can find. Okay, I'm sorry. Maybe just have people hold their questions. Oh, okay. Maybe we should wait, and I've got a couple more I want to get through, and then we'll have. I'll go quickly through two of these that I have. I have these in here kind of under what I'm kind of viewing as political political process cases. And the reason why I've got this one on here, so this is Missouri as well as some Louisiana, and then some private individuals are suing multiple entities in the Biden administration for their, specifically the CDC, Centers for Disease Control, the Surgeon General's office, for their pressure, coercion that they've placed on social media companies to moderate the content on their platforms, specifically to take out misinformation about vaccines and COVID. So this started, social media companies were, allowing posts to remain on that had misinformation, disinformation, and various entities and officials in the Biden administration leaned on them very hard to take that stuff down and to change their content moderation policies. So there's a couple of questions here. One of them is, does this violate the First Amendment rights of the people whose content was removed? One of the things that I always tell my students is, you only have First Amendment rights vis-a-vis the government. So, if I'm a private citizen and someone posts a comment on my Facebook page and I don't like it, of course I can block that. I can't do it. It's not my job to protect everyone else's free speech. I'm a private citizen, and social media companies are private entities. They're not the government. And so, they have historically been able to operate without kind of being viewed as a government entity. So they don't have to worry about the First Amendment. They can block anybody or deplatform people. But the question here is, does the fact that the government was really directly leaning on them and exerting influence on them, did that suddenly transform their activities into government activities because they were kind of being guided by folks in the Biden administration? And then there's kind of another interesting question, or did that violate the social media companies' First Amendment rights by being sort of pressured to change what they had? And, so this is a very thorny question, sort of how and to what extent social media companies can be sort of forced to act by government or coerced or persuaded. And the reason why I say that this has, I think, a political or a political process element to it is because there were some instances of also officials leaning on social media platforms to take down disinformation and misinformation about voting. Somebody posts something saying, hey, this polling place is closed, and it's not. Or guess what? Everyone, if your last name starts with P, you can't vote, whatever it is. So they were also trying to do kind of election integrity things. On the other hand, you can also see where that could, the shaky territory there, what the government is trying to affect what people are posting about on a private social media company, even one that's, is widely used as, things like Facebook and Instagram. The potential both for sort of vast misinformation to be spread is significant, but then also when government starts interfering with what should be taken down and who should be deplatformed and sort of forcing the social media companies to act at the government's behest, that's also a pretty scary situation for a lot of people. So this has not even been argued yet, but I think it's going to be a really interesting case to see. They could punt and say that the pressure that the Biden administration put on wasn't significant enough to constitute coercion and just leave it at that. But at some point, they will probably have to deal with this issue. Okay, just a couple quick ones. There's another gerrymandering case. There have been so many, but this one is kind of important because this has to do with the South Carolina State Legislature redistricted, and basically in the process of doing that, they did what they said was a political gerrymander. It also looked like a racial gerrymander, in that they moved 10,000 Black voters out of one district and into another, in a way that really they didn't need to do. They moved a lot of kind of voters around if there was a much cleaner way to do the redistricting that wouldn't have involved moving so many black voters completely from one district. They kind of carved out a big chunk. They claim it was political. It also looks racial. You know, in places like South Carolina where voting patterns and race overlap almost completely, it's hard to know what the difference is between the two. But there's a legal difference, of course, is that racial gerrymandering offends the Constitution and is illegal. Political gerrymandering, it's not that it's legal, it's that the court has decided in this Russo versus Common Cause case that the Supreme Court has decided that federal courts really just can't get involved. If there's allegations of political gerrymandering, that's just not the sort of thing courts should look at. So I always tell my students, which basically means it's legal, because if the federal courts aren't going to do anything about it, it's going to continue happening. So this is just really interesting because it's going to sort of test the limits of race as proxy for political characteristics, and could create a new House seat or not, which for Democrats, where one used to be controlled by Republicans. So depending on how this case comes out. So that's pretty significant. The last two that I want to talk about briefly are some Trump cases. But I just didn't feel like I could leave here without at least talking about a few. And there are two. So the first one, this is one that's already been answered. But it was, I know this was a really big topic. And this had to do with the Colorado Supreme Court had ruled that former President Trump was ineligible to appear on the ballot, the primary ballot, or the general election ballot, because of his role in the January 6th, 2021 events. And in particular, the allegation that his conduct violated Section 3 of the 14th Amendment, which disqualifies federal office holders if they've participated in an insurrection. This really hasn't been used very much since the Civil War time. I mean, since the 1860s, when when this was put in because of the Civil War. So this is not something that has been tested a lot. The court didn't rule that Trump was eligible. So that's an important thing. The court didn't rule on what role, if any, he played and whether that constitutes insurrection and whether or not he should be on the ballot. The court answered a very narrow question, which was just, should a state court be allowed to make that decision? And this was a unanimous opinion. It was per curiam, which means it wasn't even signed. It's just sort of from the court. And it was pretty clear at the oral argument that the court was very nervous about articulating any rule that would allow states to disqualify presidential candidates or any candidates for national office, but particularly presidential candidates. Because, today it might be Trump, and then tomorrow it might be a Democrat, and it could just turn into sort of political wars happening at the state level that affect the entire country. So the court thought, and I think this is supported by the text of the amendment, that if someone's going to be disqualified, it's going to have to be Congress. Congress is the one in charge of enforcing this amendment. It specifically references Congress. Is Congress going to do that? I think that that's unlikely, but that is where the power for this should lie. And then finally, this is probably the other, really big one looming, has not been argued yet, but it has been docketed. Is a former president immune from criminal prosecution for conduct alleged to involve official acts? And I'm going to put that in quotes, because that whether or not his conduct constituted an official act of the president has not been determined, but let's assume it was. Is he immune from criminal prosecution after he leaves office? That question has never been answered. The court has found that the president is immune from personal civil liability for damages based on official acts that he takes while in office. But the court specifically didn't rule on the criminal issue. And some of the court's rationale in this earlier case from 1982, said, civil cases are about money, and we really don't want presidents, worrying about, their pocketbooks while they're making official decisions that'll skew what they do, and that could be bad. But the court specifically said, of course, we're not talking about criminal stuff here. That's a question for another day. The day has come. And so, obviously in the lower courts, there was a lot of skepticism to the claim that the president can do kind of criminal acts and face no consequences. I suspect that the Supreme Court will also be very skeptical of that claim. It's hard to imagine a court endorsing the thought that somebody could commit criminal acts while in office and really have no consequence for it. But, we'll have to see. Again, this question of whether what he did was an official act or not is kind of a side question, but I think the squarely presented question is, if it was, can he be criminally prosecuted for that? So that remains to be seen how that comes out. They need to move quickly because we've got an election coming up. But I'm happy to answer questions or have some discussion about some of these topics. We'll start here in the room and we'll see what's coming in. Yeah, okay.
If what Trump did during the January 6th uprising was not an official act, would that make a difference in whether he
Yes.
could be prosecuted?
Yes, so the court has, again, they haven't squarely ruled on it because they haven't ever been asked to, but the court has said in dicta, of course, if the president just, runs over someone with his car or, shoots someone and it's in no way connected to his official acts, then of course he can have criminal liability. So the court has said we should extend the definition of what an official act is as far, we should let that be pretty far because, we shouldn't be too narrow in determining what an official act is. But if something clearly lies on the other side of that, then it's not going to be a basis for immunity. Yeah.
Can you speak just briefly on the difference between an originalist perspective versus not? And how that is a framework in addressing some of these court cases?
Sure, yeah. So the originalist perspective in summary would be someone who believes the Constitution to be interpreted according to its literal text as much as possible and what that text meant at the time it was written. And so a very good example of that would be Justice Thomas's opinion in the New York v. Bruen case, the gun case, where he said, whatever, however we interpret the Second Amendment, we should interpret it, as it was when it was applied to the states in 1868 and what people thought it meant then. And so kind of the idea behind it is we shouldn't be judges, so the justices that adhere to this, and Justice Scalia was another really prominent adherent to this method, is that sort of justices of today shouldn't be substituting their opinions and thoughts and feelings for the beliefs and intentions of the framers who drafted that language whenever it got put into the Constitution. So they meant it at the time they wrote it to mean something, and that meaning should be preserved as much as possible, because failure to do that would be then to kind of open up the Constitution to kind of whatever the fad of the day is, and whoever the justices on the court are and what they think. Of course, the counter position to that would be the living Constitution position that many of the court's more liberal justices adhere to. Stephen Breyer, who's not on the court anymore, but he was a very vocal proponent of this, said, those words, give us guidance, but of course we have to interpret them according to all sorts of things that are relevant today. We can use principled ways of doing that. We can adhere to, values and norms of democracy and civic participation and equality and things like that. But we of course need to move things into a more modern time because we now live in a more modern time. So that's the kind of counter argument or the counter way of interpreting the Constitution. And then, as we mentioned, there's often other considerations that might come in that don't have anything to do with how we interpret the text, but that might be just something the court wants to consider at any given time. So yes, the originalist or the textualist really looks to what was happening, how were words interpreted at the time they were included in the Constitution.
What if there is nothing that is analogous? Like you said, that you didn't have domestic violence because women didn't have any rights.
Yeah.
I don't know if there were restraining orders back then or
I
not,
don't think so.
but if you don't find anything analogous, then are you free to set a precedent with a court ruling?
I think what they would say is you have to look for the closest analog you can find, and then if you can't, then you have to look to some very specific kind of constitutional values. But yeah, I mean, they will try to find the closest analog that they can. So it does sometimes lead to kind of absurd results.
I have a chat question.
Oh.
related.
Sure.
The person says, maybe I misunderstood you when you were talking. But why does Justice Thomas, being just one justice, get to determine that the court must go back to 1868 for reference?
Well, so it was I mean, he wrote for the majority. But I can't remember if it was a 5-4 or a 6-3 split on that one, but he was writing for a majority of the court. And I think the reason why I sort of single him out, because he is a very strong originalist and strong textualist. And so the fact that he got to write that opinion and be the principal author and put that view in is very significant. The Chief Justice is the one that usually assigns the opinion writing. And so the Chief Justice, let him do that. And some of the other justices expressed a little bit of misgiving about it. But I mean, the fact remains he was able to do that. And he'd been wanting to do that for a while. He made pretty clear that was his goal.
What happens?
Another chat question is, how could the Loper decision, that was, I think, the first one you got,
Yeah, the hearing.
affect other areas of government and our lives? And we have to say, if you speak from the audience without the microphone, it doesn't get picked up on Zoom. So if you want to speak, hold up your hand and Marilyn's going to bring it to you.
So how can the Loper-Bright decision affect the government and our lives? So it could affect our lives in the sense that regulatory agencies are the ones that actually do most of the things that affect our lives in all sorts of ways. They're the ones regulating health and safety, regulating food and drugs, regulating medical devices, regulating workplace safety, sort of all kinds of highway safety, sort of all the regulations that exist that we just sort of function within come to us from these regulatory agencies. And so if they're not able to act sort of without specific congressional authorization, that means a whole lot of regulations will go away. And of course, the people who are arguing for that would say we're being crushed by regulations, by unelected bureaucrats are making my job so much more expensive, or whatever the case may be. That's the argument, is that this is kind of undemocratic, that these people have this much power. But the sort of the practical side of it is our government can't practically do this. Congress can't possibly do all of this. They recognized that and created these agencies and sort of delegated their power to them at a time when that was approved of by the Supreme Court. And, that seemed to work. That was a good workaround. And so if that gets taken away, that agreement and that ability to delegate the authority gets taken away, we would see a whole lot less regulation. And we would see a whole lot of cases now going before the court, because that would be where they would be challenged. And it could be just millions of cases. So that would be, and then we would see Congress maybe having to fill in the gaps. And I think Congress, they'd have to hire so many more staff. So it would just, things would suddenly get very, very different.
Here's an original wisdom follow-up. You want to just read it?
If that is the meaning of originalism, then shouldn't the Colorado determination to exclude from have stood the test? Because it seems the 14th Amendment is self-executing. Or can a person be an originalist one day and something else the other day without being inconsistent?
Yeah.
So I would say for the latter question, yes, sometimes justices are originalists when it suits them, and then when it doesn't. Some are very consistent. I mean, I will say Justice Thomas, he is quite consistent. With the 14th Amendment, it's not self-executing. It specifically has this clause at the end. It was like the last little bullet on the slide that says Congress shall enforce this provision. And so that language made it look pretty clear that Congress is the one that's supposed to do it and not state courts. But I do agree that sometimes justices change their stripes kind of depending on what works the best for them.
Thank you, first of all, for being here. This is a very informative talk, so I just want to say thank you so much for talking about things. I like what you said about the justices are human, especially like knowing with the Dobbs decision, how people feel about Roe, and yet they acted differently. And I know that you're one person also, but it's hard for me not to ask your opinion. We've heard some about the possibility of adding more justices to the court, and I'm just curious if you would speak to that.
So I think my personal opinion is that it's probably a non-starter. It's been floated out before at a time when the Supreme Court was extremely unpopular, back in the 1930s. And back then everyone hated the court, like Congress, president, everyone was really upset with the court for blocking kind of a lot of New Deal stuff. And the president floated the idea out there. Nobody really took it all that seriously, except the justices on the court. One of them kind of changed his views and a couple of them resigned. And so it kind of did lead to some changes on the court, but no one actually, the actual addition, the idea of adding new justices didn't go anywhere. And I don't see it going anywhere now. It is the thought of kind of tampering with the court is one that I think freaks people out, no matter which side of the aisle you're on. Because it's sort of like, well, if it gets done, then, this time, what happens the next time when it's, it's a liberal supermajority and people don't like that, and then they want to add more conservatives. I mean, I do think though, it's reflective of something really unfortunate about the court, which is the bizarre way that people are appointed to it. And the fact that President Trump was able to put 3 justices on in his 4 years in office, and President Obama was only able to have 2 during his 8 years in office. So that's just a quirk of when people resign or when people die. And, I think there has been some thought that it would be nice to have a more systematized way of appointments so that it reflects, the duration of a president's time in office, to make sure that, presidents can appoint kind of relatively, to how long they've served and things like that. So, I mean, I think that's the bigger, I think that's why people are dissatisfied right now, because we have seen it sort of Democratic presidents have not been able to nominate significantly fewer justices in the last like 30, 40 years than Republican presidents have, just because of timings of when people have died or vacated.
Mitch McConnell.
Yeah. And so I think the Mitch McConnell trick there with Merrick Garland, I think that's one of the things that kind of set people's view of the Supreme Court to go downhill, because it suddenly just looked completely political. Even though, we know it's political, we know, Democratic president's going to nominate somebody that's, politically aligned with their views, but this was like so blatant. It was like pulling away the curtain and just, so I don't think though that the court, that adding justices is going to go anywhere. I think it's personally.
I'm kind of torn when I hear states' rights versus not state rights, and it seems like we vacillate depending on the topic. Because we're such a mobile society. I mean, even just voting rights. We moved here from Texas, and I had to figure out what my process was when I got here, whether or not I was automatically, when I went to change my driver's license, was I automatically set up as a voter? And what do I need when I go to the polls? And we're so mobile these days, and yet the court will say, on reproductive rights, it's the state's right. On voting rights, we take away the pre-clearance, and now it's the state's right. And so, as we're so mobile, and I know that back when the Constitution was developed, it was very important to have states' rights, but we weren't nearly as mobile as a society. Do you see any shift in, or are we holding tight where the law prescribes to those state rights?
Yeah, I mean, and that's such an interesting question, because exactly what you said. I mean, things, we are living in a much different world than when the Constitution was, the 1790s. I think a few things have happened. In some ways, our economy has federalized. A lot of congressional power to regulate the economy has really federalized. We've got the rise of the administrative state that now does all sorts of things that most of us don't even think about, but that just happen. So I think in some ways, kind of the federal government has become the more dominant, player in when it comes to a lot of things, particularly the economy. Where the retrenchment, or not retrenchment, but where the kind of press for states' rights comes is with rights, with individual and personal rights. And that is where I think we're seeing, we've seen it. I mean, it's always been there. Throughout in the 1950s and with the civil rights movement, that was a strong states' rights was kind of leave it up to the states to decide whether there should be segregated, bathrooms or, drinking fountains. So, I mean, that was always kind of there, and it's still there now, exactly as you talked about, like with Dobbs, throwing it to the states suddenly means we can have very different rights-based landscapes depending on where you are. As you all well know, voting is mostly left up to the states. There's a couple things the federal government says, can and can't happen, but the processes and the requirements and all sorts of things that can be is left up to the states. So when it comes to kind of individual rights and freedoms, that is very much a state, it'd be very much dependent upon the state that you're in. And that is, I don't want to call it a trend because it's always been there, but that's definitely a view that, and certainly some of the justices have it more than others.
We have two chat remarks.
Okay.
One was about, she points out that McConnell reversed his position on filling a Supreme Court opening close to an election.
Right.
That's a real, here's another question. And it's back to the discussion about how to change or improve in some of our opinions, the Supreme Court. What about having a fixed maximum 20-year term for justices?
Yeah, something like that would at least create some regularity, so when a justice is appointed, so there's you can have a time frame. It would also, I think, do a lot to help people feel a little better about, justices who are on there for kind of ever and ever. That was kind of what was going on in the 30s when there was the last time that this was seriously considered. The average age of the justices on the Supreme Court were all kind of, I think, well into their 80s at a time when people didn't often live that long. And so then in the 30s, they would have been people who had, kind of grown up in a much different time while the world was changing. And there was this thought, we just got to get them out of there. So, I mean, I think it would address some of the concerns that people have, that people may be out of touch. It also might just create regularity so that we would just know, instead of it being up to when someone dies or whether Mitch McConnell's, on board, so I think that would be something. It would require, I mean, there would have to be a change to the Constitution. We would have to, that's the tricky thing, is that's a hard.
This might be the last question, but it's the most important one.
Okay.
what are the chances there will be ethics requirements put in place?
I think the ethics requirements, I think they're gonna do something, but it's gonna be something that really needs air quotes around it. I don't, it's, again, there's a separation of powers issue, because like the Supreme Court is the ultimate arbiter. And so giving them power to kind of police the Supreme Court to anybody else is something that, you know, would change the balance of power, and that the Supreme Court isn't gonna want. So yeah, they may agree to some voluntary something, but it's not, it's not gonna be something that satisfies most people.
Yeah, okay. I was just gonna say, my opinion on that, this is an opinion, that people appointed to be Supreme Court justice should be so beyond reproach, that they don't need written guidelines. They just should be a person, who's kind of moral and ethical.
Yeah, it's really interesting how just all of our norms seem to have changed. Conduct that, like, I think the framers just never thought people were gonna do. And it's similar for the president. There's some, you know, court opinions saying, well, we don't even need to worry about this because the president will never do anything that, you know, that would even approach this. So I think it's really interesting that just some of our assumptions that now have to be questioned, and then we find ourselves without any guidance because they never thought they had to address this kind of question.
I'm Holly for the Columbia Missourian. Just real quickly, going back to US versus Rotimi, can you talk a little bit more about the possible implications for women if that federal law is not upheld, and even for other people in general, what potential concerns should people have?
Yeah, I mean, so I think just as a women's issue, since women are the ones most likely to be getting those kinds of restraining orders against an abusive partner. No, it's not the only people, but you know, they're by far the most likely, and they're the most likely to be killed by a domestic partner using a gun. If that law that says your guns need to be confiscated, or it's illegal for you to be having a gun while you know, are subject to a protective order, if that law is no longer good law and unenforceable, then that would lead to a situation where just, you know, where people would be able to keep access to firearms. And I think everyone is worried that it would result in a situation with more people who are in danger of committing violence with access to firearms, and that could lead to people being hurt or killed. Yeah.
All right, well, I think we could be here another couple of hours.
A whole semester long class, in fact.
This was so great. Thank you so much. Thank you all for coming, and those folks on chat, and for your excellent questions. And
Yes,
thank you
good
again to the
questions.
library and Lauren for co-sponsoring this with us. I'll just give you a couple of announcements of some things coming up. There is an election forum that the League of Women Voters and the library will be co-sponsoring on Thursday, March 21st at 6 p.m. right here in this room, or also online. And that is a local election. So there will be candidates for Columbia School Board and City Council, and also the Proposition 1, which is the Boone County ballot issue. So that will be right here at 6 p.m. on March 21st. So mark your calendar. And 6:30, yeah. Oh, it's 6:30. Oh, okay. And then, you know, every month we do this lunch and learn, which is a great time to really learn a lot. I mean, this was amazing. Delighted. The next lunch and learn is Wednesday, April 10th at noon, again, right here in this room, or also online. And the presiding commissioner for Boone County, Kip Kendrick, will be here to give an update on the current Boone County planning process. So we hope you will plan to attend. And thank you all again for being here today. Have a good rest of the afternoon. It's lovely out there.
Thank you, Brian.
Thank you.
Thank you.